I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. It's the summer of 2024. And so what does that mean? It means most of the state legislatures are done with their legislative seasons and have passed their privacy and data-oriented bills. This year, like 2023, like 2022, we've seen a record number of privacy and data-oriented legislation stemming from comprehensive privacy laws to AI legislation. And so on this episode, we wanted to give you a recap of the flurry of legislative changes that happened between the time of January 1 and June 1 of 2024. And to discuss, I've invited my colleague, Harsimar Dhanoa, to the podcast. Harsimar is an associate on the privacy and cybersecurity team and a frequent guest of this podcast. Harsimar, welcome back.
Thanks so much for having me back. Really appreciate taking the time to unpack everything that happened, through the course of the first half of 2024.
Yeah, so let's just jump right into it. So, one of the things that I think you do very frequently for clients is tracking the legislative changes that are happening so that clients understand, where those changes are happening, importantly, so that they can get out in front of any of them if they want to engage in the legislative process, but also importantly to understand what impact these new legislative changes are going to have to their businesses. So let's start with that first category. I think in 2024, we've seen a number of new states adopt comprehensive privacy laws in the mold of the CCPA, but perhaps with important differences. Where have we seen states enact those laws?
So we've actually had 7 states in 2024 that have enacted legislation. For better or for worse, actually, a lot of them don't end up following the California model. They follow the sort of model that we see in Virginia, Colorado, Connecticut, basically everywhere outside of California. But even though there's a lot of harmonization that is happening, I think lawmakers are really starting to understand the fact that if they take a law or a bill and they propose something that is similar to what a business needs to comply with in other states, there tends to be a lot less opposition. So we're seeing a lot of these sort of copycat bills, but that hasn't stopped legislatures from adding their own spin to things and start to add new requirements that will build on sort of the core across the country.
So maybe what are the 7 states that adopted the new laws, and are there important differences that you would want to highlight in any of those laws?
Yeah, Scott, I won't name all 7 of them, or at least I'll try not to, or get something closer off the top of the head, but it's Kentucky, Maryland, Minnesota, Nebraska, New Hampshire, New Jersey, and I think Rhode Island. I think that's all 7 of them.
There you go. See, the audience doesn't know that this is a totally non-scripted program. So there is evidence that Harsimar has it all of just the top of his mind. So if you're thinking about all of those 7, do you see any kind of particular differences that are noteworthy, especially as organizations look to expand their existing privacy compliance programs for other states to these new 7 states?
Yeah, I think the big one that really everyone should be talking about is Maryland. And really the main aspect there is around data minimization and purpose limitation. A lot of states previously have taken the model that, listen, tell users how you're going to use their data. And as long as you tell them what you're going to do and you make sure that your uses are limited to what is reasonably necessary to accomplish those purposes, then for the most part, you're good to go. But Maryland really changes this framework and says, no, we're going to actually start to focus in on what is the product or service that a consumer has specifically requested and say, that is really what you should be using data for. There may be some, other use cases on the edges that there are exceptions that can help to cover, but really sort of tying that data minimization, purpose limitation provision to what is the user actually asking, what service are they asking for? And for a lot of companies, that may not require a big shift in what they do in practice. But at the outset, it's going to require thinking through, how closely am I already aligning to this? Do I need to make some changes? And just thinking through that process is going to require at least some level of investment up front.
Yeah, data minimization is one of the most difficult components of data protection law, especially because it needs and requires, in order for it to be effective, true data retention policies and strategies, which has maybe as everybody who has been through a data retention work plan, it is very challenging to do that effectively. And so you're pointing out, I think, what will be a significant change in at least the legislative change under these comprehensive laws.
Yeah, that's right, Scott. I mean, even to that point of building out these policies and thinking through these pieces, you have other states like Minnesota, which now has a requirement that you need to document, your actual privacy practices internally as well. And so to the extent that, some of the thinking may have just been happening within the chief privacy office or within the legal team, now you have states that are actually saying, no, we want you to put these down in writing. So that way it's formally documented and you know that you've thought through this as well. There's also an interesting provision there in the data security language that says you also need to do a data inventory. So now we're starting to see, some of those pieces that seemed like nice to have becoming must-haves as well.
Right. I mean, and almost similar to more akin to the EU model, right, where you have kind of an emphasis on internal documentation, policies and procedures, DPIAs, all of the different types of obligations you have for accountability. In order for you to be able to meet those standards, now we're kind of seeing those expressly stated in Minnesota. We've seen that with some of the orders that have recently come out from the FTC. And so my guess is that that will be another trend to watch.
Yeah, that's exactly right.
So let's move then to maybe a bucket two where we saw a lot of legislative activity, and that's online safety, everything from kids to content moderation. Interested in your perspective, what have we seen during the first half of the year on states moving in that area?
So children's online safety and content moderation, I think, has been one of the bigger pieces that we've seen state legislatures take on. And it makes sense. I think it's very clear for lawmakers that they want to show their constituents that they care about kids and they care about kids online. And so they want to take action and start to put in some framework in place. The challenge has been when it comes to actually, when the rubber meets the road and you have to put pen to paper, actually defining the contours of what might count as, a social media platform or what you may need to do under an age-appropriate design code is much harder when you actually have to put it in practice. And so we're seeing, a lot of lawmakers go back and forth and say, okay, we understand what we want to do, but how exactly are we going to make that happen? A lot of these laws have been making their way through, and we're starting to see more legal challenges against them. Surprisingly, Maryland was one of, I believe, the second state to pass an age-appropriate design code type law. And that's happened as California is going through sort of judicial scrutiny of theirs as well. And so a lot of states are trying to pass laws and see where the courts end up landing with the hope that, if it passes constitutional or judicial muster, then they've got them on the books. And if not, they'll see where, the courts land and then refine them as needed.
So on these set of laws, is there any type of consensus building that we have seen, or are these much more bespoke to the state who's passing them?
So there tends to be broad trends around, what exceptions you might see, in terms of, what platforms are considered a social media platform or not. The challenge is that there's a lot of, I think with every state, no one wants to just take the law from the neighboring state and say, we're just going to pass it here. Everyone wants to add their own spin to it. And so we just naturally tend to see some of these deviations, either in definitions, in the way that provisions might be worded slightly or obligations are worded, or even the exceptions. And that's where you start to get to some of the challenges around, well, if a law in state A ends up getting ruled unconstitutional and the law in state B is very similar, should we go and actually take this and think, yes, this will actually, have an impact on the business, or do we hold off and wait to see if the law in state B also gets struck down?
Broad brushes, what are the requirements under these laws?
So it'll depend. If you have some of the age-appropriate design code type laws, they tend to be around looking at the various harms that users, and in this case, users under the age of 18 might experience while using their platforms. So that tends to be the more intensive side. And then you have some as well that just say, listen, before you can have someone under the age of 18 sign up for your platform, you need to collect their age information. And if they are under 18, then you need to apply some additional restrictions on how you might use their data. I will actually say that that second bucket, even though it sounds simpler, can be still quite challenging, because if you have a site that has a mixed audience, so maybe primarily folks who are over 18, but some folks who are under, you get to be in a tricky place where you may have to ask your over 18 audience to provide information about their age when before you never had to. And so that can cause some heartburn for businesses as well.
And you mentioned this, and this is not the show that we're focused on, the reviewing all of the judicial actions and court rulings that implicate privacy in cyber. But importantly, this is an area that I think is actively being watched by different organizations, especially around First Amendment grounds and in California in particular.
Yeah, no, that's exactly right. And because there are pieces in some of these online safety bills that are in, like you mentioned, general comprehensive privacy laws or cybersecurity laws, these cases are being watched very closely just to see if there are lessons from those judicial opinions that can be applied to some of these other, I'll say, less controversial pieces, but that may have similar obligations or requirements.
Yeah. All right. So that's bucket two. Third bucket, probably everybody's favorite bucket, is going to be artificial intelligence. States have also started to weigh in on AI. I think we did a prior episode around the new Colorado law. What activity have we seen, and where do we expect that to go?
So the Colorado one really is the main one with the Colorado AI Act. I think what's interesting here is that, similar to with kids' online safety, strong appetite to regulate and sort of meet the technology and meet the moment where it is. But when it comes down to putting pen to paper, that's when you start to realize how much more challenging this can become. Colorado is a sort of unique situation where a lot of folks are unhappy with where the bill landed. And even the governor sort of signed it reluctantly and sort of gave a stern talking to lawmakers to say, listen, there's time before this takes effect. I want you to go meet with constituents, meet with stakeholders, and refine this so that we're not hampering innovation unnecessarily with this law. I think folks are starting to realize it's a tougher piece, and a tougher way to say, how do we scope this so that we are making sure it's future-proof, but also not so broad that companies don't know how to handle it. Interestingly, it's slightly outside of the realm of the state legislatures, but California has been having a similar issue with the CPPA, the California Privacy Protection Agency. They've been working on automated decision-making regulations and have had to sort of go back to the drawing board around how exactly do we want to scope this and who do we want to be actually caught within this framework, because they know that if it's too broad, it's going to end up hurting innovation much more than what they actually want to see happen.
Yeah. Meanwhile, we have the EU AI Act, finally be published, and now with concrete timelines associated with compliance. Do we see this as going to be an area at the state level that we should be tracking carefully, especially as lawmakers look on the other side of the Atlantic and start to see, a much more robust version of an AI legislation start to take effect?
God, I think that's exactly right. I mean, I know that the past doesn't always predict the future, but if you think about privacy, we had the GDPR as sort of a stage one in Europe. And then lawmakers in the US at the federal level said, we as the US need to have a comprehensive federal bill. We're still waiting on them. But the states really met that moment and actually stepped up and said, okay, we're going to start to pass laws that get at some of these core protections that are in the GDPR. And so I can see the EU AI Act starting to motivate a similar movement here in the US of basically motivation within Congress to try to regulate AI. It's the same conversation around how do you balance these protections and still preserve innovation. And I think states are going to say, listen, we're going to try to do something. The states are sort of the laboratories of democracy. So, we may try something and see if it works and refine it over time because they're more agile in that way. And so I wouldn't be surprised if we see more states like Colorado that pass their own version of an AI Act.
And then we've seen at least one state, Utah, I believe, pass a law that requires at least disclosure-oriented obligations surrounding when it is that you're using AI or interacting with AI.
Yeah. And I think we may start to see a range of folks and different approaches, similar to what we've seen with the privacy bills, where some states may focus more on transparency. So, like Utah, letting someone know when they're interacting with an AI bot or an AI model, to things like Colorado, where it's more involved and more focused on, well, when you're developing the AI model, what exactly are you assessing? We may eventually see ways of, opt-out rights or even prohibitions on using certain AI tools in certain contexts. But I think we'll need to see where the market of state legislatures goes and where the risk appetite for lawmakers ends up being.
And so that's bucket three. And then I'm guessing we didn't say that there was a fourth bucket, but there probably always is secret bucket four. And secret bucket four for this case is maybe like all of the others, because in addition to those three big categories, that doesn't mean that that's the full landscape. In fact, I think there are many other areas of law that things have changed, everywhere from amending and making tighter data breach notification statutes, issues surrounding health, privacy, reproductive rights oriented issues, kind of, all of those various things that we've seen over the course of 2024. Interested in whether you've seen any themes come out of those other category.
I mean, I think the biggest one that has come out is around health privacy and reproductive privacy. I think we saw Washington last year pass the My Health, My Data Act, which was really a high bar in terms of what those protections will look like. And now we've started to see states who've seen that high bar and taken maybe a slightly more nuanced approach that captures, well, are you actually using this data to learn about someone's health, or is it data that maybe incidentally could reveal that type of information, but that's not how you're using it in the first place? And so I think what we're really seeing is just the natural evolution of someone's planted the flag in the ground, people are reacting to it as they try to operationalize it. And then as other states say, hey, this seems like a good idea, there's just more nuanced and involved conversations around, listen, we tried this, or we're trying to comply with this one state, and here's how it's impacting us. Here's how it actually is protecting consumers, or maybe, isn't actually meeting that goal. And so we start to see more refined proposals down the line. One piece too, not exactly in this secret bucket four, but just thinking back to bucket one of the pieces we didn't talk about is, a key state that didn't pass a comprehensive privacy bill, which was Vermont. And Vermont, they've got a little bit of bucket one and bucket two. It was a comprehensive privacy bill with some age-appropriate design code language in there. But one of the key differences is that they also would have granted a private right of action. And this is one of the sticking points at both the federal level and that, consumer advocates have really been pushing for with some of these state proposals. And we saw that the private right of action really was a sticking point for lawmakers. Originally, the bill passed in the legislature and was vetoed by the governor. And it didn't end up having the votes when it went back to the legislature to try to overturn that veto. But it's an interesting perspective of, I think normally when we see these, they either die in committee or we just think, okay, they're going to go ahead. And here's one where there was a lot more nuanced conversation around, listen, I know the legislature wants to do this, but is this the right choice? And really when the legislature took a second look, they said, maybe we need to pump the brakes here.
Now we're midway through, a little bit more than midway through 2024. As I understand it, the busy season for the state legislatures has passed. There are a few year-round legislatures that will continue. Predictions, early thoughts on what we can expect for the second half of 2024? Or are we really waiting for spring of 2025 before the next burst of privacy-oriented legislation?
So it'll be an interesting moment because at the federal level, a lot of attention is going to be dedicated towards the election. And so we may see some coordination that takes the wind out of state legislatures in the second half because they're working with their federal counterparts to campaign. Or we may see sort of the movement where, because there's not as much federal action on certain legislative topics, that states see this as the right opportunity to try to jump in and make the most of the space that is there for them to pass new laws. At the very least, though, the start of 2025 is going to be sort of the next wave. I did the math, it was around 7 or 8 last year in spring 2023, 7 this year in spring of 2024. So my guess is we may hit something similar of about 7 or so states in spring of 2025. That number could go up as more states end up realizing, hey, listen, there's a model that works and we can get it passed through relatively quickly and show that we care about privacy. But I wouldn't be surprised if it did.
But we're running out of states that don't have the laws, Harsimar. I think, what are we at, 25 now? So at some point, that number's got to go down.
I keep telling myself that the number, it needs to slow down at some point, but I wouldn't be surprised if someone who was back, 2 waves ago says, hey, we want to go and revisit and revamp this framework. And then they're back on the drawing board.
Boy. All right. Well, Harsimar, really appreciate the update on the legislative development front at the state law level. At some point, I'll probably have you back and we can talk more about what's happening at the federal level, everywhere from the FTC to the courts and to the action or inaction by United States Congress.
Thanks for having me, Scott. Really appreciate getting to talk about this. And like I said, there's a lot going on, so happy to help folks make sense of it.
Great. With that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.